make a start so you can get us out of this heat a little bit quicker than thing. So, croeso i'r cyfarfod y prynawn 'ma. Welcome to this afternoon's meeting of Planning, Regulatory and Licensing of 5 p.m. Wednesday, 8th of July 2026. Please note that today's meeting may be recorded. This recording will be broadcast on the authority's website and may be used for training purposes by the Democratic Services Department. All attendees will be in view of the camera, and by attending, you are consenting to being filmed and to the possible use of those images and sound recordings being used as outlined above. Agenda item number 1, apologies for absence. Do we have any? None? All members are here. Fantastic. Item number 2, declarations of interest. Members are reminded of their personal responsibility to declare any personal and prejudicial interest in respect of matters contained in this agenda in accordance with the provision of the Local Government and Finance Act 1992 relating to council tax, the Local Government Act 2000, the Council's Constitution and Members' Code of Conduct. Members are reminded they must identify the item number and subject matter that their interest relates to and signify the nature of the personal interest, and where members withdraw from a meeting as a consequence of the disclosure of a prejudicial interest, they must notify the chair when they leave. Do we have any declarations of interest? Councillor John Thomas.
Yeah, thank you, Chair. Item 4 on the agenda, private hire vehicle licence. I take a personal and prejudicial interest in that, as I hold licences myself and I also work for the company involved.
Are there any other declarations? No? Thank you very much. Item number 3 is an exempt item. In order for the following to be considered in private, it is suggested that the public be excluded from the meeting on the grounds that it involves the likely disclosure of exempt information as defined under Part 4 of Schedule 12A, Section 100 of the Local Government Act 1972. Can I have someone move Section 100, please? Councillor Michelle Jones, thank you. Can I have second it? Councillor Clive Jones, thank you very much. And then, due to the exempt item, the live stream will now be paused. No, sorry. Need a vote on it first, sorry. First one. Sure if you can vote on that then, please, guys.
Yeah, definitely. Section 100 is carried.
Section 100 is carried, thank you very much. And due to this being an exempt item, the live stream will be temporarily paused and we will return shortly. So we move on to agenda item 5 is the minutes of previous meeting.
Just move for accuracy.
Can I just have someone move those for accuracy, please? Clive Jones?
I move, Chair.
Thank you. Can I have a seconder, please? Fabulous. Thank you very much. Councillor Jill Preston, second that. Thank you. Yes, if we take that to a vote then, please. No questions, comments?
That's carried unanimously.
Fabulous. Thank you very much. It's been carried unanimously. So item number 6 then is plan application P/23/0065. And I will hand over to Judith to present this agenda item.
Thank you, Chair. On the 7th of January 2026, Planning Committee resolved to approve this application subject to 53 conditions and subject to the applicant and any other interested parties entering into a Section 106 agreement. Since then, officers have been working with the agent representing the applicant to refine the conditions. Whilst the information required to be submitted has not changed, a condition requiring details of phasing prior to reserve matters stage has been added at the applicant's request at condition 5 in order to enable a phased approach to the delivery of the development. Relevant conditions have been amended to reflect this. Some environmental and travel and parking conditions have also been merged or removed to avoid duplication, resulting in an overall reduction to 43 conditions and subsequent renumbering. The applicant and any other interested parties are still required to enter into a Section 106 agreement. The amended conditions are set out on pages 22 to 37 for committee's consideration. So committee are asked to approve the amendments to the set of conditions relating to planning application P/23/0065.
Fabulous. Can I have someone move? Questions? Sorry, I will get there, I promise. Any questions? Councillor Clive Jones.
Yes, thank you, Chair. I've got two. I welcome the fact that the number of conditions have been reduced from 54 to 43. Does that mean that in the meantime, the developers are still working on the detailed application? The fact that it's reduced to 43 and they've obviously agreed all those, does that mean that the detailed application will be submitted perhaps sooner rather than later? And have we any idea at all when the detailed application is likely to be submitted?
I don't know the date when it will be submitted, but I know that the agents for the applicant are working on the application, preparing it to be submitted, yes.
I mean, my concern, Chair, is the length of time that we've been dealing with this, the fact that it was deferred to the Welsh Government, which added on to the time. And I know that you haven't, by the sound of it, any indication, but I think we would all be interested, Chair, and certainly the public would be, as to any idea when this application is likely to be submitted. All I'm saying is I know that there's discussions ongoing, Chair, with the planning officers for quite some, ever since January. All I'm looking for is that we've got some time, some indication. Are we able to find out from the developers? Because currently, I don't think any elected members got any idea whether this is going to take another 6 months, another 12 months, 18 months, or 2 years before the application is submitted.
Yeah, we can certainly ask the agent to provide the committee with some indication, yeah.
Thank you, Chair, that would be very helpful. My other question is on page 22, a bit lower down under the heading Purpose of the Report. It states the applicant and any other interested parties are still required to enter into a Section 106 agreement. I understand that relates to a playground area on land which is not in the council, it's in private ownership, is that correct?
No, that's not correct.
Right.
If you recall, the report that was presented in January had the heads of terms in that. I think there were 5 bullet points, Craig. But I think the area of land you might be referring to is the area of land required for the biodiversity enhancements.
Ah, right. Okay. So there would be no issue with reaching a 106 agreement. That's not fraught with any legal aspects.
No, that the contents themselves of the agreement, in terms of the obligations themselves, are agreed. There's just some sort of technical issues to do with the sort of wording and all sorts of things before it's finalised.
Okay, thank you, Chair.
Thank you very much, Councillor Jones. Councillor Ernie Goldsworthy.
Thank you, Mr. Deputy Mayor. I got 2 questions, please. Yeah, as a member of the Planning Committee, I have been there for over 30 years. I have never seen so many incredible conditions as 53 on January the 7th. The amended number on 43 are also incredible. I am really worried because it may cause the applicants to consider leaving the site. If the conditions were withdrawn totally, what issues would there be to the council, and also would it cause financial difficulties? Thank you very much.
Thank you. So the conditions have all been agreed by the applicant. The difficulties that they potentially would face, and these are part of the discussions that we've had, could be legal challenge if there weren't appropriate conditions attached to the planning consent. So for a development of this scale, of this nature, that number of conditions is not unusual. If you looked at planning consents granted in some larger authorities that often have these type of developments, then you would see that. So they are there to protect both the authority and the applicant.
Yeah, would there be any financial problem with it?
As a result of legal challenge, there could be, yes.
Okay, thanks.
Are there any other questions? Councillor Clive Jones.
Chair, when I hear a reply that mentions legal challenges, I always get a bit wary. Could you give an example, Judith, of what a potential legal challenge could be on any part of this application?
So every planning application, once it's granted, is subject to a 6-week period, Geraint, where anybody can judicially review the planning permission. So it would be subject to that, the same as any other planning permission granted.
So my further question, Chair, is, are the officers anticipating that there will be a legal challenge during that 6 weeks?
I couldn't possibly know that.
Right. In other words, we are totally unaware at the moment.
Perhaps I could assist.
Do you want to put your mic on?
Councillor Jones. Anyone is perfectly entitled to bring a challenge against any decision of the council, but they do have to pass certain thresholds. So if they were bringing judicial review against the council, there are certain thresholds that they would need to get above in order for the court to grant permission for the judicial review to proceed. So I think Judith is quite correct. We simply don't know whether any application's being judicially reviewed. What it requires is for all councillors to act transparently, apply the code of conduct, all the training that you've been given in relation to making planning decisions. So basically what you do when you make any other planning decision, you just have to make it properly in accordance with the law.
Right. Thank you, Chair. I think I'm a bit reassured from our legal officers sitting here in the Planning Committee.
Thank you very much, Councillor Jones and Goldsworthy. If we have no more questions, do we have any comments? Again, Councillor Clive Jones.
Yes, originally I shared a lot of the concerns that Councillor Goldsworthy's made. I think it was Councillor Goldsworthy's mentioned 53. I think it was 54 with the number of conditions. I understood that the fact that this is a huge scheme, that from a planning point of view, we would need to secure a lot more conditions than many others, but particularly with this size of this scheme. And I want to reiterate the type of questions I asked previously, Chair, and say here that as far as the public are concerned, I am continually being asked. I've no doubt that every member present on the planning committee and who are not on the planning committee are being asked by their constituents as to where we are, when will we start on this scheme. And I am really hoping that they are well on their way and have been carrying out all the necessary work and still will be. But I look forward personally to an application being submitted within the next few months, because I think everyone would be more than happy to see that happening. With this scheme, as we said in the original planning application in January, we'll have a huge economic reflection on the community of Merthyr Tydfil, with over, I think it's 800 jobs, and the number of facilities that will be there. It'll be, frankly, in my opinion, the making of Merthyr Tydfil. So I look forward to the detailed application.
Thank you very much, Councillor Jones. Are there any other comments? No. So,
Just say something.
of course you can.
Before the chair takes it to the vote, can I just remind councillors that we are looking at the conditions now on pages 22 to 37 of the report. That's what they're being asked to vote on, and it would be those conditions with a section 106 being entered into, so no planning permission will be granted until that planning permission is signed up to by all parties. Thank you, Chair.
So, with that information being provided, can I have someone move the amended conditions as seen in the report?
And I second that, Chair.
Thank you very much, Councillors Tovey and Clive Jones. So can we take that to the vote then, please?
That's carried unanimously, Chair.
And that's carried unanimously. Thank you very much. We now move on to agenda item 7, which is P/25/0253 63 Brecon Rise, and I believe David is taking this one. David, over to you.
Thank you, Chair. I'll just screen share some slides as well. Okay. Okay, so this application relates to land at 63 Brecon Rise, and it's for the erection of a dwelling with associated parking and landscaping works. Members will recall that this application was previously presented to the Planning Committee last month in June, and that a decision at that time was to defer the determination of the application until further consideration of the highway implication, to enable further consideration of the highway implication for the proposal. In particular, there were concerns that the development would impact on the existing parking arrangement in the area, which is already considered to be congested. Following the committee meeting, the applicant's agent submitted a plan to illustrate how the proposal sits alongside the existing parking in front of the adjacent garages, and I've got a slide to show that. Additionally, the head of engineering and highways was invited to comment further on that plan, and in light of the concerns raised, it was reiterated by the engineers that the off-street parking proposed for a relatively small bungalow was deemed to be sufficient. It was noted that there is indiscriminate parking on pavements in the area, and this was not deemed to be acceptable, but was also considered to be a separate enforcement matter, which is normally dealt with by the police. As such, they've maintained their advice that the proposal would not give rise to any highway safety concerns, and accordingly the recommendation is the same, that the application be approved subject to the conditions set out on pages 49 to 51 of the report. So just to recap very briefly, the red outline is the extent of the application site, but the area of land that's to be developed is essentially to the side of the property. As you can see, this is a snapshot from Google Earth, just showing some of the parking in that area. So you can see parking takes place typically in the hammerhead, and then also parking takes place in front of the block of garages. This plan just illustrates the position of the house, as I said, to the side of number 63. The driveway parking area is on the end here, and this extended red line that extends to the adopted highway to allow essentially a crossover into the site. This is the floor plan. As you can see, it's a fairly small property. It is 2 beds, but the overall size of that is fairly small. So this is the plan that was submitted by the agent. So they've highlighted that the garages there, which relate to various properties within the cul-de-sac. They've highlighted that there would be a drop curb provided at the end of the footpath here, where there'd be a crossover leading into the site to accommodate 1 parking space for the new development. This photo you probably saw last time. So this is effectively where that wall is. That's where the new bungalow would be located, effectively hard on the edge of the footpath, like the wall. There's a bit of this sort of darker shade of the wall here. That's where the wall sort of turns around, and that's essentially where the access into the site would be. I guess, just to highlight some of the parking issues, because obviously the photos that we've taken are sort of during the day where there might not be as many cars parked. So we had, as one alongside one of the representations, we had some photos provided which highlighted the parking in the evening. So you can see in these 2 images the sort of the dark Audi car there. That's roughly where the access or crossover into the site would be. And as you can see from the photo, there are cars parking on pavements as well. And again, this shows the sort of the parking that takes place within the turning area. Obviously, deliveries sometimes occur there, and this, I guess, this top photo sets out, you know, the extent of the footpath around that area. I don't think there's really much more to add to that, other than to say that the highway engineers did come back and highlight that the parking spaces in front of the garages, even though that's something that's regularly undertaken, they've noted that this area is actually part of the adopted highway and it's not a formal parking space for residents. So even though that takes place, that's not in their mind formal parking areas, although it does seem that there would be some space even if a car's parked on there for for people to walk around past the vehicles. So yeah, thank you, Chair. Any questions?
Any questions from members? Councillor Salmon.
Thank you, Clive. No, I just want to put on record that I would have had questions if someone from Highways and Engineering had come tonight, but they've refused to come. So I would just be going over the questions I asked last week. So I've just got a little comment after. Thank you, Chair.
Any further questions? Councillor Clive Jones.
Well, I've got at least 2. If you look at page 44, and it's headed Character and Visual Amenity. And in the middle of the first paragraph, and I quote, "It is therefore important to consider the character of the surrounding dwellings and how the proposed bungalow would sit in the context of the street scene and existing pattern of development." Having read the report, am I right in saying that there is one other bungalow in the whole of the Brecon Rise estate? Is that correct?
Sorry, my mic was off there. I can't put a number on how many bungalows there are in that estate. I know there's one sort of just at the junction here. This sort of T junction. There's a bungalow just there, so there's one within close proximity of the site. But that's not to say that when we're assessing the design and the character of an area, that everything has to be identical. There is a mixture of house types and finishes in this area, which plays into that. So the fact that there's a bungalow amongst two-storey properties in itself is not necessarily problematic. You often find that in other areas. I think if there's a clear design on every single property where it's consistent, and then you introduce something that is completely different, that then may be a cause for concern. But in this instance, the houses have all got different features to the front of them, for instance, around the cul-de-sac.
Well, having read the report, I could only find a reference to one other bungalow on the whole of the estate. So 99% of the properties, Chair, on the Breckenridge estate are houses. So I presume we take into account that it is a bungalow, and in the question of recommended approval, it doesn't matter if there's another bungalow there, or do we take into account that there is a bungalow already on the site?
We've acknowledged, I think, that there is a bungalow in the area, but that in itself isn't the only consideration. In terms of when we're looking at the design and character of the area, we've looked at, the style and design of all the properties in the immediate vicinity. If we were minded to refuse an application simply because it was a bungalow, we would have to then demonstrate what harm that's causing to the character of the area, other than it just being slightly different. But as I say, I don't think in this particular estate there's a degree of consistency that would support that.
And Chair, in reference to the amount of cars that are parked there, I think it's already been mentioned this evening that it's accepted that if you drive up to this estate, any time, I presume, after 5:30 in the evening, the number of cars being parked there is considerably more than during the daytime. Do you accept that, David?
I think from the photos that I've seen, that would suggest that there are different levels of parking taking place at different times of the day. I can't say for sure if it's consistently congested, but obviously the photos I've seen from the objectors suggests, there are cars that park in the turning heads and park in front of the garages.
My line of question is, we've had this crop up in numerous other planning applications in relation to traffic flow, and every time the photographs seem to refer to somewhere during the daytime, maybe late morning, when it's not a true reflection of the number of vehicles there. And this was the case here in Breckenridge. Do you accept that?
Can I just come in?
Well,
Yeah, just on. I think since this was presented last month, we have updated the presentation to sort of show, because we do appreciate, like quite often we take some of the site photos from Google Street View, Google Earth, and we have no control over what time of day those photos are taken. So I think in order to show the situation as full as we possibly can, that's why we sort of added to the presentation from last month to give a sort of more accurate reflection of the parking situation.
I understand that. All I'm saying is the same should apply to other planning applications where we have a true reflection of the number of vehicles that are parked in the street, and nighttime will tell you exactly what the score is.
I think that's something we can take on board and just ensure that's reflected in future applications. Yeah.
That's great, Craig. My other question is on page 47, and it's under the heading drainage. And it's a very interesting paragraph there. And they say that Do Cymru Welsh Water being consulted in the application, they offered no objection in principle to the disposal of surface water into a sustainable drainage system, subject to consultation agreement with the regulatory body or riparian owner of the system. And this is the part I've underlined. However, they have highlighted that the site is crossed by a public foul and service water sewer, and were concerned that the development would be situated directly above the public aspects. Now, reading the rest of this, they appear to say that they would have to look at this and carry out work so that if approval is given to this bungalow, it doesn't cause a problem in the future. And my question there is, if that is the case, it is going to cost a lot of money, and I presume Dŵr Cymru will fund the cost of that, or is that something funded by the owner of the plot?
Yeah, so so what they've highlighted is, as you say, there's a sewer that crosses the site. It's not unusual that this can take place. If it's a particular main sewer, that can be more challenging to move. But in this instance, they have no objection to that. And the cost of doing so would be, I would normally expect it's from the developer. Welsh Water themselves wouldn't bear that cost. They would forward that on to the developer.
So just to be clear, Chair, before any work can be undertaken on this plot, Dŵr Cymru are saying that the public sewer would have to be moved.
Yes, they would need to agree the diversion of that sewer.
Okay, thank you.
Are there any more questions? No questions. Any comments? Councillor Salmon?
Oh, thank you, Chair. It's just quickly, it's just disappointing that no representative from the Highways Engineering Department has attended tonight's planning committee meeting to answer members' questions. Given the importance of highways considerations in planning decisions, their absence is, to be honest, is concerning and limits members' ability to properly scrutinise and understand the advice being provided. Once again, I believe it would be down to elected members to bear the brunt of residents' frustrations when parking issues arise. Thank you, Chair.
Before I bring in Councillor Clive-Jones, Judith, you wanted to come in on that?
Comment?
Yeah, I just wanted to clarify something. Highways officers didn't refuse to come to planning committee.
I had a phone call.
They weren't required to. I appreciate that you made a request, but the role of the planning officer is to set out the case to members in the report, including detailed all the detailed consultations that were received from the various consultees, including engineering and highways. And then on that basis, it's the planning officer's role to make a judgment and arrive at a recommendation. So all the information that members require to make a decision is in the report. So it was on that basis that highways and engineering officers weren't requested to come to planning committee.
Nobody from the planning department could answer the questions that we wanted to ask in regards to why they allowed it. You know, going by you look at the photographs. It's obvious this is going to cause issues. We see this, Judith, we see this numerous times over and over again, to be honest.
Yeah, the information required to make a decision, albeit it may not be one as per the recommendation, there is sufficient information in the report to make that decision, hence why the officers weren't requested to come to the meeting.
Okay, no problem. I won't be voting for it anyway.
Thank you, Councillor Salmon. Councillor Clive-Jones?
Chair, I completely agree with Councillor Salmon. This is not the first, and I disagree, the engineering manager or a very senior engineer should be present at the meeting. This has happened, as Councillor Salmon has said, time and time before. We aren't asked questions, and the planning officers are trying to do their best to answer a particular professional highways question, and there are times when they cannot. If they are not a professional highways engineer, I would put it to you, it's very difficult to answer a question. I'm disappointed. I think this should be referred elsewhere. If we are at a planning committee and have got any clout from now on in the future, if we would make a unanimous decision to invite, and it's a very rare event, if we make a decision to invite a specific officer, it should be accepted, agreed, and they should be sitting up there on the top dais to answer questions from elected members.
Noted.
Any more comments?
Are there any more comments? No, not that I can see. Right then, so I will need someone to move the recommendation that the application be obviously approved. Even if it's just to move progress.
The application.
Thank you very much, Councillor Tavy. Can I have someone second it, please? Councillor Michelle Jones, thank you very much. Right then, take that to the vote then.
That's carried. Chair Officer's recommendation is carried.
Officer's recommendation is carried. Thank you very much. Right, so we will move on then to agenda item 8, and that is application P/26/0029, plot for Oakland Business Park. And I believe I'm handing over to Gareth for that one. Gareth, it's on you.
Thank you, Chair. This application is presented to committee at the request of Councillor David Jones. His principal concern being the amount of work taking place around the site and the effect that's having on the removal of trees and ancient woodlands, deposition waste, material on site and material affecting the local water course. The planning application itself seeks consent for placing 52 steel containers within a well mesh compound. The units would be rented out to the public for private and personal storage purposes. On the plan you see in front of you there, you see the access road down from Bogie Road past Unit 1 to the site, which is outlined in red. Can we scroll down a little bit, Dave? Perhaps. There you see the aerial photograph there. The site is sort of bottom centre to the obviously developed area there. Thank you. And if you take it down further, we might see the plans, which would be useful because that gives you some idea of the array of both the array access arrangement into the site, the placing of the actual storage units themselves, and the size and dimensions of the containers. No objections have been received to the application from statutory consultees, and the public consultation resulted in one letter of objection being submitted, full details of which are included within the report itself. Notwithstanding the rural location, I think it's important to mention that the earlier consents on this site, including the consents that were issued, that resulted from an appeal back in 2008 and 2011 for industrial development on the site, are a very material consideration, not least because the reserve matters that followed that application has been partially implemented with the access road being developed into the site. And the net result of that would be that those industrial units that were approved in detail back in 2011 could still be built. Highways have not raised any objection to the proposed development. If you scroll down again, I think, Dave, we've got a photograph there of the main access from Bogie Road into the site, haven't we? And there you see that there. It's a sound junction. There's good visibility to either side, so understandably highways haven't raised the issue. They just briefly, the design and scale of the proposed development is considered acceptable in the proposed landscaping scheme, which you saw on the screen that we just scrolled past, I think, would, with the benefit of time, deliver both net biodiversity benefit to the development and also help in terms of screening of the development itself. And as a result, a positive recommendation is made. I would stress that the landscaping area there is outside of the application site, but within the control of the developer, so he could still implement the landscaping scheme. And as I say, a positive recommendation is offered.
Right, before I do bring members in for obviously questions and comments, we have got a public element of the of this part of the meeting. There are no physical objectives for the the item, and the applicant isn't here either, but Councillor David Jones does wish to make representation, so I invite Councillor David Jones to speak now.
Thank you, Chair. This first statement is from a local resident and should be considered in conjunction with a series of photographs that have been provided for you. Sorry, I don't have references to each of the photographs. I wish to object to this application, not because I oppose all development on the site, but because I do not believe the committee currently has sufficient information to be satisfied that the proposal fully complies with the Council's policies relating to biodiversity, landscape protection and sustainable development. My principal concern is that the application appears to assess the site as it exists today, rather than properly considering the environmental baseline that existed before the unauthorised clearance and site works took place. The officer's report states that the site has limited ecological value and that no preliminary ecological survey work was considered necessary. However, local residents have witnessed the removal of trees and vegetation that previously provided natural screening and habitat connectivity between the site, the surrounding countryside and the adjacent ancient woodland. Members may also be aware that the wider area has been the subject of biodiversity initiatives undertaken by the Merthyr Biodiversity Partnership, including work to support hedgehog conservation and the installation of awareness signage. Whilst this does not prevent development, it demonstrates that the area is recognised as contributing to local biodiversity objectives and forms part of a wider ecological network. This is particularly important given that the site directly adjoins protected ancient woodlands and lies within the Merthyr Tydfil landscape of outstanding historic interest. These are sensitive environmental designations that warrant careful consideration. My concern is not simply whether the application site in its current state contains significant ecological features. The question is whether the site contributes to the wider habitat network associated with the adjacent ancient woodland, surrounding vegetation and local biodiversity initiatives, and whether that role has been fully assessed before a decision is made. The committee is being asked to conclude that there will be a net biodiversity benefit through replacement planting and bird boxes. Whilst these measures are welcome, I am not convinced that sufficient information has been provided to establish what habitat value existed before the recent clearance works, whether ecological connectivity has been reduced, whether any biodiversity losses have been properly quantified, and whether the proposed mitigation is proportionate to any impacts that may already have occurred. My second concern relates to landscape impact. The report places considerable weight on historic planning permissions and concludes that the principle of commercial development has already been established. Whilst I acknowledge that planning history is a material consideration, the committee must determine the application that is set before it today in the context of current policy, current site conditions and current environmental duties. The photographs I have provided demonstrate that the character of the area has changed significantly following vegetation clearance and earthworks. The loss of established screening has affected both the visual appearance of the site and its relationship with the surrounding countryside. Planning Policy Wales emphasises the need to concern and enhance the countryside for its ecological, landscape and cultural value. Policies ENW1 and ENW5 similarly seek to improve ecosystems' resilience and protect landscape character. I am not satisfied that the impacts of the recent site changes have been fully assessed against those policy requirements. Finally, I would ask members to consider public confidence in the planning process. Residents have observed vegetation clearance, the importation and storage of materials, and substantial changes to the site and surrounding land. Whilst I appreciate the report's position that unauthorised works are separate planning enforcement matters, there remains a legitimate concern as to whether those changes have influenced the environmental assessment now before the committee. I'm not asking members to determine whether those works are authorised. Rather, I'm asking whether you can be satisfied that the biodiversity, landscape and environmental assessment reflects the true condition and ecological value of the site before those changes occurred. It will be just 2 more minutes, Chair. Another resident has raised two issues of concern. Firstly, regarding the unauthorised tipping of materials on the site. What materials have been tipped on the site, and are they all inert? Are there materials which have been tipped which could potentially leach to an adjacent watercourse? Perhaps not today, but in 1, 5 or 10 years' time could end up polluting the watercourse onto the River Taff. Secondly, the resident has concerns regarding SUDs. SUDs are the sustainable drainage systems, which are nature-based surface water management solutions designed to mimic natural drainage, slowing down runoff, reducing flood risks and filtering out pollutants under Schedule 3 of the Flood and Water Management Act 2010, where any constructional work spanning over 100 square metres requires formal SAB approval before any construction begins. The resident believes that the works carried out on this site do not comply with this very important act in an area which has been flooded many times over the years. The replacement of a natural environment with a compacted surface and an impervious topcoat is likely to lead to faster surface water runoff and potential flooding, as well as other concerns raised in the Act. Both residents respectfully ask that the committee either refuse the application or defer determination until the environmental implications of the site works and vegetation clearance have been fully investigated and assessed. Thank you, Chair.
Thank you very much, Councillor Jones. Do we have any questions? Councillor Clive Jones.
Well, my first question, Chair, is I am concerned at the number of things that have been said by Councillor Dave Jones. Several aspects of it. And we do not have the objector here or the proposed developer. My view is, in view of what you just heard and what I've read in the report, I think we should defer this application until, and is it possible, I'm looking at Geraint, if we defer it, can we give an opportunity and a request that the objector and the developer must attend that meeting? Because I have questions probably, well, I certainly have with the developer, and I may have questions with the objector. So what is the score there?
You can make a request, Chair. What we cannot do is demand that they turn up.
No, I understand that, but I don't understand, frankly, in view of what's involved in this report, where neither of them, was there a reason why they couldn't attend, or we give them opportunity?
I think from what you're saying, Chair, you would like the opportunity for both parties to turn up so you could ask them questions.
Yes.
Where you may actually find yourself in September, when this matter would return back before Council, Planning Committee, is that neither may turn up.
Yes, well, I accept that that's a possibility. I'd be very surprised if the planning committee accepts what I'm saying. I'd be absolutely amazed that if both of them didn't turn up.
I mean, I was just wondering, do the planning officers have any particular...
Yeah, just come in there. I think we also need to be aware of how it's phrased in the Constitution, and the public speaking element can only occur one time when the application is presented to the committee. And we did have an objector register, but it was past the deadline. And it says that usually applications, when they're deferred and coming back, the public speaking opportunity is sort of lost because it's already been provided at this point. It hasn't been taken, so it doesn't...
Yeah. I don't know the circumstances, but there can be a number of reasons why either party have missed the deadline. I don't know what the reasons are, but frankly, particularly what David Jones has said and what I read here, I think there is real merit in deferring this for the opportunity to be given for them both to attend and ask questions on both sides.
Just make one more point in relation to the application and other proceedings that are going on at the site. The determination of the application, if it was to happen tonight, be it a positive or negative decision, wouldn't prejudice any enforcement action that is underway on site. There are 2 live enforcement cases on site, and whichever way a decision was to be made on this wouldn't prejudice that process would still carry on in its own regard.
Right. But, so it should, I would say, Chair, yeah. But, I'll test the meeting. I move, Chair, that this planning application is deferred to the next planning committee in September, and that the developer and the objector are specifically asked to attend the meeting in accordance with the Constitution.
I mean, all I would say, Councillor, sorry, I haven't quite got used to this sort of new speaking system. I wasn't at full council last week. The Constitution, as Craig has pointed out to you, doesn't allow for that to happen. The opportunity for the objector and the developer to speak was actually tonight.
In the question of democracy, I find it amazing that it's so tied up in the Constitution, the wording, that this cannot happen ever. I'm just amazed, frankly. So we say it categorically, what I'm saying cannot happen. It's impossible. Is that correct?
They've had their opportunity to speak. All the I mean, the objector has decided not to speak. The applicant has decided not to exercise that right. We cannot make them speak. As I said, we could, if the opportunity was there and it was deferred till September, there's no guarantee that they would turn up then either. But the Constitution as it stands does not allow for it. It states that they are to speak on the first occasion when the matters come before you.
Those that are experts on the council, both officers and elected members, I think perhaps should look at this particular question, because in the first of democracy, I find that really off-putting.
I am quite happy to have that conversation with you, Councillor Jones, if you wish to come and see me.
Yeah, well, yeah. I certainly want to see. I mean, there's pages and pages of it, and I'm not aware of the new wording in there. But site meetings are going out to the window, Chair. It's impossible to have those now unless the director specifically has a matter that she wants a site meeting on. So in all ways that we look at it, we can't give these applications the time and the energy and the questions that are required.
We're still on questions, obviously. So, Councillor Clive Davey.
I've got questions as well.
Oh.
Yeah, I just wondered who published this document. There was no acknowledgement. Was it like an objector or the council?
That was submitted yesterday by Councillor Jones.
Councillor
in advance of speaking tonight.
Okay, thanks.
That's the only question, is it, Clive? Right. Quick move on to. Right. So, move on to Councillor Declan Salmon.
Thank you, James. It's just really quickly. It is. It's just asking the question. Surely this application shouldn't be in front of the committee until both enforcement cases have been satisfied.
So in terms of the enforcement, I mean, this application is limited just to the area that Gareth set out, which is the only aspect of this site that's being considered. The areas where other enforcement issues are taking place, which obviously need to be addressed separately, is the land to the west of the site, where I think reference was made to tipped material, and there's a little compound there to the side of that. And I think the area where perhaps more groundworks and vegetation lost is over on the eastern side of the site. We've got enforcement cases on both of these, which are being reviewed. I think there's some issues with land ownership on the eastern part of the site. But in any case, those persons responsible are not, they're not related to the applicant. The applicant has sold those areas of land, so they're a separate matter.
Were they sold before the works were done?
I don't know if they're sold before, but my understanding is that the land to the west and the east are outside of the applicant's control. I think this plan here perhaps show, I think it's the first plan. So this is the area of land which is obviously the red line, which is the main access into the site and the main development area, and the two blue areas is the area of land within the applicant's control. But the enforcement is essentially to the side in those blank areas, which we're still reviewing.
Yeah, solicitor just wants to come in on this a minute. Don't forget your mic.
Could I come back to Councillor Jones's request for public speaking? I'll read out what the Constitution says. Public speaking will be permitted on one occasion where applications are considered by Planning Committee. When applications are deferred, and particularly when re-presented following a committee resolution to determine an application contrary to officer advice, public speaking will not be permitted other than in exceptional circumstances with the agreement of the chair. So it could be deferred, you could make your request, but there has to be exceptional circumstances. So you would need to satisfy, well, it would be with the chair's approval, that there are exceptional circumstances in this scenario or in this application as to why it should be deferred with public speaking at the next planning committee.
Right.
Put that.
Yeah, not a second, but obviously come back to that with you, Clive. But obviously I'll move on to Councillor Michelle Jones now.
Yeah, my question is in relation to Clive's comments. So has the applicant or the other party made any kind of comment as to the reason why they didn't attend today? Was there any kind of justifiable reason why they weren't here, or did they just refuse to attend, knowing that this was their opportunity to be able to answer questions and make comments?
Yeah, we can't compel applicants to appear and speak at committee. It's a decision for them themselves. So they haven't refused, they just haven't come forward to speak.
They haven't come back to us and said, is there a possibility that I could come on a different
Yeah, not the applicant, no.
Okay.
Sorry, before I bring that, am I right in saying that the objector did put in a request, but it was beyond the
It was
deadline?
past the deadline,
So
yeah,
they
that's
would have
correct.
been here had that been obviously within the.
Yeah, if it was made in accordance with the process. And
So they wanted to be here, but obviously couldn't because they missed the deadline. That's what I wanted to get at. Fabulous. Is that all the questions then? Thank you, Councillor Michelle Jones. Councillor John Thomas, you next.
Thank you, Chair. If I take you to page 56 under the heading Publicity, just a couple of questions for clarity, really. It says at the first bullet point, lack of transparency in advertising the planning application with concerns that no neighbour notification was sent. Can you tell the committee how this was publicised outside?
The application was advertised by means of site notices posted in the area, including either side of the access point of the road. There's no obligation to actually send neighbour notification letters. The regulations say that it can be one or the other or both. In this case, it was just site notices.
Well, I was under the understanding that... sorry, go on. What was that?
I was just going to say the report notes there was 4 site notices placed around the area.
I thought in previous applications, residents close to the proximity of whatever planning application it is would get a letter drop as well.
So in terms of the regulations, it's usually one or the other. Typically, you would do letters where you've got properties adjoining the site. So in this case, you haven't really got any properties adjoining it other than the individual plots around the site. So in this instance, site notices was the best way of communicating the application, because otherwise there's always the question, if you do a property that is so far, why not the next property a bit further? So we've got to try and be as fair as we can on that.
Okay. The second bullet point then, the application states that no trees would be lost. This is misleading as a number of trees were removed prior to the application being made, and as a result, habitat loss has occurred without the benefit of any evaluation. Was the ecologist or the planning committee aware of these works carried out before the planning?
In terms of the council ecologist was consulted on the application and didn't object to the proposals. The complainant isn't being particularly specific as to where the trees were removed. Looking at historical aerial photographs of the site in particular, and in relation to the ancient woodland that you see slightly to the south of the site, The embankment did have some self-setting trees there on the last sort of set of photographs were taken around 2002, which have clearly been quietly growing there. They appear to have been removed, but that is something that the applicant could have done anyway. In terms of the site itself, well, the site itself is something that has been surface hard standing certainly since 2008, because I took a quick look at the planning inspector's report earlier this afternoon on where the industrial development was initially allowed, and she was quite clear in her assessment of it that the actual site was just flat road hardcore.
Okay, yeah.
Yeah, I think part of the concern probably stems more to the eastern part of the site in the left-hand photo over in that area where there has been some works to the embankments there. That's the area that sits outside of this application, has been undertaken by somebody else. When we looked at the aerial photos for this particular site, you can see various degrees of vegetation that has sort of been cleared and sort of, I guess, sort of re-established a little bit like the grassland areas. But I think on this embankment, as you can see, there is some scrub and vegetation around there, and what they're proposing to do is plant quite a number of trees, which would, far exceed what was there in any case on that site.
Yeah, okay, Dave, thanks. Authorised work should be investigated prior to the application being determined. If I take you to this pamphlet that we had, it's on the 6th of the 11th, 25, a water pipe being installed and directed into the stream. That's one. Also, the illegal tipping of car parts and whatever else waste. Have they had permission from NRW? Because I see NRW saying no objection, but have they been informed of all this unauthorised illegal work that's been going on?
Yeah, I spoke to one of the objectors yesterday in relation to that, and she raised those two specific issues with me at that point, and I then suggested she contact NRW as those issues would be within their remit. So I would assume the objector has contacted NRW for them to take those issues forward.
So although then it's been flagged up to the planning committee, it doesn't come under your remit to report it as such. It's got to be down to the objector or the resident, whatever.
It's been reported now. Anyone could report it, but I think in this case, given that the application was still under determination, it was better off to come from the objector.
Okay, thanks, Rick. Thank you, Chair.
Thank you, Councillor Howes. And Councillor Clive Jones.
Right, shall I start with the Geraint Morgan, who's read out the relevant part of the Constitution, so correct me if I've misunderstood it, but the wording is that we can defer this matter if there are exceptional circumstances and with the agreement of the Chair.
You can defer it.
Yeah.
The issue is whether they can speak at the next meeting, and that's with the agreement.
I don't think you're on.
I'm sorry. It can be deferred. That's always your entitlement that an application be deferred. The actual speaking is with the agreement of the chair at the next committee. Shall I read it again for you, Clive, so that everyone has got it? Public speaking will be permitted on one occasion where applications are considered by planning committee. When applications are deferred, and particularly when re-presented following a committee resolution to determine an application contrary to officer advice, public speaking will not be permitted other than in exceptional circumstances with the agreement of the chair.
Well, it's the last bit.
Yes, it is the last
just
bit.
read out. It's very important. Yes. And I think there is an aspect of that the planning committee can fully utilise so that we get to the real facts of this case before we come to a decision. I mean, we've had two local ward members here, one's a member of the planning committee, and Councillor David Jones have made the committee well aware there are a number of concerns. You only have to read the report here to determine that there are a whole host of concerns. So I'm still of the view that the opportunity, because of the unusual circumstances, that there's an opportunity given to both parties, because I think there are questions to be answered on both sides before we come to a decision. Now, I have questions, so I don't know whether I stay quiet if there's further comments or other questions, but I have questions on what's in here.
As to whether you want to ask them, the primary question is whether you're actually asking for a deferment still.
Because
when it comes
I
back
haven't changed my mind, and I hear what you've said in the Constitution. There is an opportunity, and frankly, I believe that wording needs to be looked at very carefully. Again, when we make real huge decisions here affecting people in the community and developers for that matter, that we have a full opportunity of discussing applications thoroughly. And that includes being made an offer to the objector and the developer to attend. And I move that.
So is anyone prepared to second that? Yeah. Yeah. Okay. Yeah.
They need to vote. Deferred to the next available planning committee, with a request that both the applicant and the objector turn up, but on the understanding that they cannot be compelled to do so. Yeah. Okay.
Yeah, obviously with the wording in that, it does quite heavily state that, you know, with my agreement as well as the chair. But I do agree, Councillor Jones, that I think we should be given every opportunity for both objector and planner to have their say. You know, we would have had an objector here, as previously stated, had they not fallen foul of the timescale. So I think I would... Yeah, and developer, yeah. But obviously the objector had put in a request to speak, but they missed the deadline. So yeah, I'd be happy to go along with that. So obviously we've got yourself as thing, we seconded it, so we'll take it to a vote then, guys.
Although, is everyone in agreement with the deferment to the next available planning committee, please vote. So that's deferred unanimously. What I'm not sure about is when the next... Sorry, that's been deferred. What I'm not sure is when the next planning committee is. All I can say is it's September.
2nd of September.
2nd of September, yeah. Happy with that?
Yeah.
This pressing the buttons become the new you're on mute, by the way, yeah. So yeah. So that's obviously been passed, that it'll be deferred to the next, obviously next meeting, and we will give the objector and the applicant opportunity to speak as well. Obviously we move on to agenda items 9 through 13, they're all information reports, so we obviously can't get to turn on those. Item 14 is any other business. I have none, and I will close the meeting. However, I would ask committee members just to sit tight a couple of minutes, because the officers need to discuss